Good afternoon. I see there's some people streaming into the virtual auditorium. Welcome to those. Please say hello. You'll see there's a chat box at the bottom. Please say hello where you're from. Say hello. This is Joe from Johannesburg or Pete from Petersburg. There we go. There's Mario from Cape Town. How's it, Mario? Welcome. Bronwyn from Brits, Northwest. How's it? There we go. Polokwane, Dundee, Edenvale. Oh man, this is lovely to see. Nice collection from all over South Africa. Look at this LexisNexis red ball with the lines coming together like sort of lines of longitude. And it's a bit like that. People from all over converging at the top of the pole. Hi, Brittany from George. Welcome. Nice to see you all. Let's give another minute or so for people to stream into the room, the last few, before we kick off. I've said this before, those of you who have attended these webinars before, I think I probably might sound like a stuck record, but it is remarkable to think that before the COVID years, we would have had to have seminars like these all over the country, hire a hall, give tea and biscuits and so on. And now we can address a vast audience, really just all online. It just is remarkable. Hi, Yoshi from Durban, Charmaine from Springs. Okay, it's 14:32. We'll give another 30 seconds or so. We'll wait till 14:33 and then we'll start properly. CPUT, some varsity people, welcome. ESI, old. There's St. Helena Bay. Hi, Ken. Right. Welcome, everyone. Okay, so let's kick off. It's already 14:32, close to 14:33. So let's start. A little bit of admin quickly. You've all said hello on the chat there, so that's very kind. Thank you very much for that. If you have any questions during the course of the webinar, please make use of the Q&A box, not the chat box, but the Q&A box. We are monitoring the Q&A box, and at the end of the webinar, we will compile the questions and hopefully be able to address all or most of them at least. So please do that. Then the other thing I want you to look out for is during the course of the webinar, there will be a poll that gets popped up, and that's a questionnaire. Those are very important for us to make sure that we serve up the correct content in webinars in the future and serve our clients best for that. So please be sure to complete those poll questions when they pop up, please. Right, so let's get to the theme for today. I said last month, it seems like we're running this family law theme, and it's been running for a number of months now, and it deals with those of you, or probably almost all of you who studied law, remember law of persons and family that you do in your first year. You deal with a handful of things: death, divorce, birth, insolvency, wills, and those are all those topics that we've addressed, some not so much insolvency, but all the others we've addressed already in our talks. But now today is a particularly special one because we're dealing with death and we're dealing with the administration of estates, but actually a very special one in that I look at it and I see South Africa kind of coming together. We've got the interpretation of the Constitution, we've got the recognition of Customary Marriages Act and case law recognizing all the peoples of South Africa. And that's really special. And that is today's theme, of course, which is Sharia law and the administration of estates. So welcome to all of you on this, I think, a very, very special webinar today. So who's going to guide us through this? Well, there's some familiar faces, me, George Findley from LexisNexis, and then we've got the formidable Gavin, who guides us through all of these courses month after month. Gavin, welcome. And Jamie Lee Lawrence as well, one of my other colleagues down in Cape Town. Jamie Lee with a wealth of experience from the Master's Office. Gavin, admitted attorney and conveyancer. But more importantly, we have a very special guest today. So it's not someone from the in-house family, but we've got Waleed Said here today. And Waleed comes with a wealth of experience, 20 years of practice experience. He's the founder and director of Said Attorneys. He's got a BCom LLB degree, lots of experience in family law, winding up of estates, property law, civil litigation, you name it. But importantly, he's got a certificate in Muslim personal law. And that makes him the expert today. And that's why it's so special to have you here today, Waleed. And thank you for being here to guide us through this. And we've got a really big audience, and that just says one story, and that is the people are dying to hear what you, sorry, that wasn't a good turn of phrase, dying to hear what you have to say. if we're dealing with deceased.
You can say that pun was intended.
Pun intended. But so on that note, I'm going to hand over to Gavin. Gavin's going to navigate us through the processes today. But again, Waleed, thank you for joining us today. Everybody, at the edge of your seat, hold on to your hats and glasses. Here we're going for a roller coaster ride. Thanks, Gavin. Over to you.
Thank you, George. I appreciate the lovely introduction. And as George said, I am also very happy to have Waleed here today. He will be our expert on our Sharia law today. I'm just going to share my screen for everyone to see. And George, if you could just give me an indication of when it shows up on your side.
There we go. It's up, Gavin, but just put it on presentation size. There we go. Good to go.
Let me just remove my video from playing, and then I can hide this. And there we go. So like George mentioned, today we'll be looking at something very topical. As we know, we have heard a lot about the recognition of Muslim marriages and how problematic that has been in South Africa, and how as of recently they have been making a lot of progress on recognizing Muslim marriages in our inheritance law as well as our divorce law in South Africa. So today we'll be looking at navigating Sharia principles when we are administering a deceased estate. Let's just have a quick overview of exactly what we'll be discussing today. So we'll start today's discussion with just an overview of Sharia law, so we can formulate a better understanding of why we need to understand these principles and what guides Sharia law when it comes to matters of inheritance. We'll also then look at the legislative framework in South Africa. We will look at some of the legislation that plays a role, and as well as the recent case law that is important for us to understand when we are dealing with Sharia law in a deceased estate. Then we'll look at the impact of Sharia law on deceased estate administration. We'll specifically look at how Islamic inheritance law affects the distribution of assets, especially regarding the deceased estate. And we'll look at the consideration of the differences between Islamic wills and secular wills and how they get applied in a South African context. And then we'll look at some key principles of the Islamic inheritance law. We will look at a basic framework of the inheritance under Islamic law, specifically focusing on two concepts. We'll focus on our mandatory inheritance shares, as well as our concept of inheritance priorities under Sharia law. Okay, then we'll also have a quick discussion on how we deal with disputes in a Sharia estate administration, as well as disputes between our local law as well as Sharia law. And lastly, we'll look at some practical examples just to showcase exactly how those concepts are applied when we are dealing with the deceased estate. Okay, so then let's get started on a bit of just a better understanding of what exactly Sharia law is and why it's important to understand its implications for deceased estates administration. Okay, so Sharia law is both a moral and a legal framework derived from Islamic teachings, primarily from the Quran and the Hadith. Okay, it includes guidance on various aspects of life, including personal conduct, business dealings, and inheritance. In South Africa, even though Sharia law isn't recognized as an independent legal system, a lot of aspects of Sharia law, specifically relating to marriage and inheritance, have been introduced into our legal framework. Okay, so for example, if we look at our Recognition of Customary Marriages Act, there's a lot of Sharia law principles that have been enacted in that piece of legislation, which impacts the inheritance rights when we apply that piece of legislation. Additionally, we do have a lot of case law that has shaped our inheritance law in South Africa. And a lot of these pieces of case law deal specifically with Muslim spouses and Muslim heirs. Okay, so we'll look at a bit more detail on those cases when we get to our legislative framework. So then we'll look at some of those cases in particular. Okay, so when it comes to estate planning, many Muslim individuals opt to align with the structures of Sharia principles, while also complying with the South African legal framework. Okay, so as we understand, Sharia law is not its own separate legislative legal system. We do understand that if we apply the principles in terms of Sharia law, we still need to adhere to the South African legal requirements and the legislation in place in our legal system. Okay, so these considerations become important when we look at things like drafting an Islamic will, appointing guardians for minor children, and ensuring the fair distribution of assets amongst heirs. We need to be able to balance not only the role of Sharia law when we do that, but also the requirements in terms of our legal framework in South Africa. Okay, so we do have guiding principles in Sharia law, so kind of our golden thread that runs through all of our Sharia principles. And these principles mainly are concerned with the concept of fixed shares and priority of inheritance. So unlike secular inheritance laws where assets can be distributed at the testator's discretion, with Islamic inheritance, there is a big impact from the Quran, which outlines specific portions for heirs, which ensures a fair and just distribution across the family members. Okay, so that then also outlines the main goal of Sharia law, which is to protect the family, ensuring dependents are taken care of and preventing the exclusion of rightful heirs. Okay, so very important then, just as a summary, why we need to understand the role that Sharia law plays in a South African context is that we will be dealing with a lot of individuals who would like the Sharia principles to be applied at the time of their death, so that they can ensure that their families are protected. So we need to understand what those principles are in order to apply them and align them with our South African legislation. Okay, so if we then look at our South African legislation, what are these principles that have already been enacted into law? Okay, so our most important pieces of legislation that we look at here is our Recognition of Customary Marriages Act, which I've mentioned previously. And this, of course, is our piece of legislation, while not explicitly acknowledging Sharia law as an independent legal system, it is vital in recognizing Muslim marriages and, by extension, inheritance claims in terms of Sharia law. Okay, we do understand that recently in South Africa, there's also been a lot of discussion and developments surrounding the recognition of Muslim marriages. And we did have a lot of cases that followed on one another that kind of called for the recognition of Muslim marriages. So we did have the piece of legislation that we refer to there, the Muslim Marriages Bill. Okay, this bill was based on an investigation by our South African Law Reform Commission. So the bill was then developed over a number of years. I think they started it all the way back in around 2018, if I'm not mistaken. And it's been quite a lengthy process to develop it completely. I think last year, towards the middle of last year, they did portions of the Muslim Marriages Bill were introduced into our Divorce Amendment Bill. So there are portions of the Muslim Marriages Bill that have already been recognized and introduced into our Divorce Amendment Bill. And that, I think, was around mid last year, around May or April last year, where that was signed into law. Okay, the purpose and the main purpose of the Muslim Marriages Bill was then, of course, to recognize Muslim marriages and protect the rights of Muslim women and children, and to address any inequalities in our statutory framework that didn't expressly provide for the protection of Muslim individuals. Okay, so key amendments here include that the definition of marriage and divorce was extended to Muslim marriages. There was more protection provided for children and dependents of a Muslim marriage. We had the redistribution of assets that became something that was allowed in terms of legislation, which was not necessarily allowed in terms of the Muslim, the Sharia law that the Muslim marriages applied. And then it also dealt with the forfeiture of patrimonial benefits in a Muslim marriage. So even though the Muslim Marriages Bill mostly deals with our Muslim marriages, it does extend into how we deal with that estate when we are dealing with the deceased estate. Okay, so it's important that we do refer to these two pieces of legislation, our Customary Recognition of Customary Marriages Act, as well as our Muslim Marriages Bill, which even though it has not been introduced fully, we can refer to the amendments to the Divorce Act that were signed into legislation mid last year. Okay, so above and beyond our legislation, as we know, they are still developing it, and it does take quite some time for it to be written into legislation. We do have a lot of case law surrounding Muslim marriages as well that guide us on how we can implement these different aspects of Sharia law when we are dealing with Muslim marriages as well as Muslim deceased estates. So one of the first prominent cases that we can look at is the top one that we have there, which is Daniels versus Campbell. And this is a case from 2004. And it went all the way up to our Constitutional Court. And in this instance, the case before the court was spouses in a Muslim marriage were not recognized under the Intestate Succession Act and the Maintenance Act. And the ruling ensured that the surviving spouse in an Islamic marriage could inherit like they could in a civil marriage as well. So the case corrected the historical exclusion of Muslim widows from intestate succession and reinforced the constitutional right to equality in inheritance. Okay, so from this first landmark case, what was introduced with this is the ability for our Muslim spouses then to inherit in terms of our Intestate Succession Act. So even though the Intestate Succession Act isn't expressly listed as part of our important legislation over there, we can see that the Intestate Succession Act can also be applied when we are dealing with Muslim individuals and their deceased estates. The second important case that we can look at here is Assam versus Jacobs. So in this case, the court addressed polyamorous Muslim marriages, and the court ruled that widows in polyamorous unions could not be excluded from inheriting under intestate succession, ensuring fair treatment and preventing financial hardships. So here the court again took it a step further and said not only are we protecting a spouse, but if there is more than one spouse, then we will be protecting all of the spouses under our Intestate Succession Act. The last case that we can look at there is Musa and others versus the Minister of Justice, also a Constitutional Court case, and this one is from 2018. And I think this was also the case that reinforced the idea that we need to amend our legislation to recognize our Muslim marriages. So here the Constitutional Court further reinforced the rights of Muslim spouses, particularly again those in polyamorous marriages, by declaring the exclusion from inheritance laws unconstitutional. Okay, so with this decision as well, they pressured the lawmakers to formally recognize Muslim marriages, and this then also led to the development of our Muslim Marriages Bill, which is still in process, but will hopefully be enacted in totality in the near future. So that then just a brief overview of the legal framework we have in South Africa. Even though we can see we do have legislation that supports our Sharia principles, a lot of it is still found in our case law up until such a time that we have a formal piece of legislation specifically dealing with Muslim marriages. Where can you find all of this case law and all of these pieces of legislation? LexisNexis does have a product called Practical Guidance, Trust, Wills, and Estates. I think there should be a poll popping up now, and this product includes all of the information required in terms of Muslim marriages, in terms of just normal deceased estate administration, trusts, etc. So it has a variety of information that you can access. So if you'd like to be contacted for that, please give us an indication there, and one of our consultants will reach out to you to give you some more information on that. So let me just give everyone a quick minute, and then we can move on. Okay, perfect. I think that gives everyone enough time. Now let's move over to our asset distribution under Sharia law. it allows me to skip over there. Sorry, a bit too far. Okay, so the next aspect of Sharia law that we'll be looking at is our assets distribution and also the interplay between Islamic wills and secular wills. So when we look at our asset distribution under Sharia law, like I've mentioned previously, Sharia law impacts how the deceased estate is distributed amongst the heirs, because we have the principles of fixed shares as well as the principles of preferential heirs. So these principles always play a role when we distribute our assets under Sharia law. Another important consideration here is the testator is limited in the amount of his estate that he can divulge in terms of a will. Okay, so if we look at our Islamic wills, typically specifies the distribution of only up to 1/3 of the estate as per the testator's wishes. Okay, although it's not obligatory, while the remainder of the estate should follow the Farid principles. I don't know if I'm saying that correctly, Walid. You can correct me later on. But that essentially means the fixed shares need to be handed down in terms of the principles we have in our Sharia law, and only 1/3 of the estate can be distributed by the deceased in terms of his will. In contrast, if we look at secular wills in South Africa, inheritance laws, you have the ability to distribute all of your assets freely. So there's no limitation on the assets that you can distribute in terms of a secular will. Okay, so while Islamic laws provide for religious compliance, we need to understand that the requirements in terms of our secular wills would still apply. So when you are drafting a will in terms of Sharia law or an Islamic will, it's important to understand that all the requirements that relate to our secular wills will still be applicable. So the will still needs to be signed properly. It still needs to be in line with our usual laws that we apply to our wills, not only our wills, but our inheritance laws as well. So it needs to align with our laws in terms of the Intestate Succession Act. Your will won't be able to override those laws. It won't be able to override any of the court rulings that we just had a look at. So if you are dealing with a Islamic will, it's very important that you consider not only the Islamic principles that need to go into that will, which is that we can only distribute 1/3 and the rest goes in terms of our Farid principles, but we also need to consider that it needs to align with our legislation in terms of our Intestate Succession Act as well as our Wills Act. So all of those legislation need to be consulted, all of those pieces of legislation need to be consulted to ensure the validity of your will as well as the distributions in terms of that will. Okay, so, and then we also need to look at managing Islamic wills and estate administration. So I've been through that just now. So we just reiterate, we need to understand that we need to meet both requirements on both sides. I'm here going to rope in Walid as well. I'm not sure if you have anything to add on this slide, Walid, but after this slide, we'll be looking at these principles in a bit more detail. And I myself have not had a lot of experience with them, so I won't be the correct person to guide our attendees on that, but I think you would be excellent at giving our attendees a bit more information on exactly how these principles are applied in practice as well as in terms of Sharia law. Over to you, Walid.
Okay, thanks, Gavin. Okay, so just where you ended off, managing Islamic wills in estate administration, obviously trying to understand Sharia principles can be very daunting, especially for non-Muslim attorneys. You know, I often get calls from colleagues, how do I do this? How do I do that? It's actually not that complicated. It sounds a lot more daunting than what it actually is. But if you just know a few basic essentials, and we'll deal with those on the next slide, so to say, then it can be done fairly easily, right? So Islamic inheritance, as it's on the screen, follows a fixed structure, right? That comes directly from the Quran, right? So that is based on the principle that whatever wealth we have comes from the Almighty, and therefore the Almighty indicates how we're supposed to distribute that wealth once we pass on, right? And that's where the fixed shares come from in the Quran. Now, we're not going to go specifically and in detail here what those fixed shares are. We'll deal with it in another slide, although not in such detail. But the key requirements obviously is, and this is obviously the role of the executor. I think something that's probably not here that just popped into my mind is one of the most important principles or issues is when you're doing your will, or when you speaking to someone in drafting the will, is to identify an executor that will be able to apply the Islamic principles if you're doing a Sharia compliant will. So step one obviously is identifying the fixed heirs, right? So that is the job of the executor. So before you can even distribute the estate and get to the figures that must be provided to all of them, you need to determine who are the exact heirs, right? Those heirs, once determined, have specific percentages that they get. So the spouse gets the husband gets a specific percentage if he's the surviving spouse. The wife gets a different specific percentage if she's the surviving spouse. Kids get, I think the most common thing that everybody knows about deceased estates, Islamic estates, is that sons get double the share of a daughter. And there's a context to that and reasons which we're not going to get into right now. And then, of course, parents also must inherit if they are alive, right? Which is something very different from intestate succession laws, where the parents specifically must inherit. And even in a will, so you can't also exclude your parents in a will, for example, right? Then extended heirs. So when you get to a situation where you don't have kids, for example, then you start looking at parents. If your parents are not there, you start looking at your parents, siblings. If there's no parents, then you start looking at your own siblings, and that's how it goes on. Those are all also prescribed in terms of who must inherit when a certain category of heir is not present, right? The nice thing about all of this is that you don't need to, when winding up an estate, you don't need to know all of these things off the top of your head or at your fingertips. Depending on where in South Africa you are, so in the Western Cape, we've got the Muslim Judicial Council. In Gauteng, you've got the Jamiat there, you've got the Jamiat in KZN. These organizations are able to provide you, for example, with a distribution certificate. So you give them the information and they give you the exact figures. Also sort of absolves us from making mistakes with regards to what the inheritance is supposed to be. That's the nice part of having these organizations provide these certificates. And in most instances, I'm not sure about the rest of the country, but I know the master here in the Western Cape, when you're submitting your L&D account in terms of Sharia, you are required to submit a distribution certificate from the MJC as well. Right? Now, when it comes to fixed heirs, as we've mentioned, it includes the spouse, parents, and children. That is generally, if those exist within your scenario, then that's the people that will inherit and everybody else is excluded, right? Other than your charitable portion. That's also important to note that from that charitable portion, the 1/3 that you are allowed to give at your discretion, you can't give to someone that's already inheriting. So you can't take from that 1/3 and give to a parent, a spouse, or a child, right? From that 1/3, you can give to family members for sure, whether it's a sister or brother that wouldn't have inherited because of the fact that your parents are still alive and you've got sons, or you can give. This is also an opportunity, for example, where you can give to an illegitimate child. So in Sharia law, from a husband, from a father's perspective, right? An illegitimate child, someone obviously that was born prior to marriage, cannot inherit from a father, but they can inherit from that 1/3 portion that you are allowed, where you are allowed the discretion. So that is where you can give to a child that was, for example, born prior to marriage, right? So on the last paragraph there, in practice, the estate administrator, yeah, as I've mentioned that already, obtains a certificate from the relevant authority. And those certificates are fairly easy if you haven't dealt with them before. It's as simple as you generally deal with what is called the fatwa department within the specific authority. Send them all the relevant details. Now, normally what we do is we simply send them the next of kin affidavit. but with a bit more context, because the next of kin affidavit is limited in terms of South African law. Whereas when it comes to Sharia law, you simply give them all the relatives that are surviving, and they will tell you, okay, these are the ones that must inherit, and these are their specific portions. I think we can move to the next slide.
Thanks, Walid. Before we move over, I hope you don't mind me just
Sure.
quickly. I just want to ask you a question. I think that a lot of our attendees today might also have in the back of their minds. So you've mentioned that we can approach the MJC or the Jamaat, depending on where we're located in South Africa. So I know, for example, if we are looking at intestate succession, or even if we are, as attorneys, giving some guidance to our clients when they are setting up their will, we do have certain pieces of legislation or documents that we can refer to where we can see all of these principles outlined. If you approach the MJC or the Jamaat, do they have processes or documents that kind of outline these inheritance shares for you? Is there some sort of place that you can be guided on how to apply these principles as well?
Yes, so there is a couple of organizations that have put together sort of an order of distribution. I've got one of those saved on my hard drive. It's simply called an order of distribution, but you could get it from your local authority as well. I'm not sure if they've got pre-saved ones that they share with people, but the tricky part with that is if you don't understand it properly, it can be very daunting, because it's like 4 or 5 pages long, gives multiple examples of if there's a son, if there's no son, if there's a daughter, if there's multiple daughters, if all of the above exist, and there's no parents, without siblings, with siblings. So it can be very, very confusing when it comes to that. But there is documents like that one can, I suppose, Google as well, and get it from an authentic Islamic website, because it's the same all over the world. I mean, it comes from the Quran, so it doesn't differ depending on which country you're in. It's exactly the same all over.
Perfect. Thanks, Walid. I think from personal experience, I've also worked with the MJC here in Cape Town, and I will say, without adding fuel to the fire on the Master's Office discussions, but they as an institution are very helpful when you are dealing with anything related to the Islamic inheritance or Islamic divorce law as well. So if you ever do get stuck on any of these principles, do feel free to reach out to any of those institutions. They are very helpful in these situations. Thanks, Walid. I'm going to hand over back.
One thing I possibly just wanted to add here quickly is you also now just mentioned the issue of intestate. Obviously, we need to remember that if the person dies without a will, right? And if we want to do it still, if the heirs still want to wind up that estate in terms of Sharia law, which is obviously their choice, then one can do a redistribution agreement and then restructure the intestate shares to be done in terms of Sharia. And then you just follow the same procedure by getting a distribution certificate from the MJC or whatever authority you fall under, and then doing your redistribution agreement in terms of those percentages as opposed to your normal intestate percentages.
Yes, that makes complete sense to redistribute it then. And then, of course, you will also have to follow some of the case law that has been introduced where they've kind of solidified those principles of Sharia law. So it's wise to always make sure that you look at all of your different pieces of legislation and your different sources before you make a decision on how you're going to distribute in terms of these mandatory inheritance shares. Thanks, Walid. I'm going to give over to you so we can have a look at our priorities as well.
Okay. So under point number 1, right? To answer your earlier question, Gavin, it was Faraid. That's the pronunciation of the word.
Thanks, Walid.
Okay, let's see what inheritance priorities under Sharia law gives precedence to immediate family. So as we've touched on, spouse, parents, and children, that's the direct inheritance, the immediate family. If those exist, nobody else inherits, right? So your parents and all of them must get a specific portion, right? Spouse, children, parents, grandparents, if grandparents are there, obviously if the parents are deceased, then the grandparents will inherit. and those portions are split depending on who exactly is around or not, right? Full and half siblings, those are the parents, the deceased siblings, that must also inherit depending on the structure of whether there's normal parents and children available. And it also obviously depends on whether you have a son or not, because in most instances, there must be a male heir. So if you don't have a son, but you only have daughters, then it often, Sharia looks for where there's a male relative. And the context of that in simple terms is that there must be a male relative that looks after the family. That's one of the obligations that is placed on a male, right? So next we deal with residuary heirs, right? After the fixed shares are distributed, and remaining estate is given to these heirs based on the relationship to the deceased. Just what we go here. Wait, there we go. So again, I wouldn't get too caught up in the outline of these things, because once you get your distribution certificate from the MJC or the Jamiat in KZN or Gauteng or any other province, then it becomes pretty simple, right? But just to go through a few of these things, you know, depending on, when you look at those lists, if you're going to go out and Google them, you'll see that depending on if there's a son alive, then they will get a certain portion. This is what the father must get. This is what brothers and sisters must get. If there's no children, parents or grandparents alive, and the ratios, I mentioned that ratio 2:1 earlier as well. The context of that again is on the basis that a male has an obligation to look after the females in Islam, and therefore their portions are double. The issue there, and a question that often pops up is, but isn't that unfair? The reality is that the portion that a female inherits is for her alone, whereas the portion that the male inherits, he has to look after the females in his family. So he can't spend all that money on himself. He has to make sure that whether it's his mother, his wife, or whoever, he has to look after them. And that is where that portion comes in, right? Then extended relatives. So again, if there's extended relatives and you want them to benefit, for example, they can benefit under the 1/3 portion that you have a discretion with, right? But as I also mentioned earlier, the Sharia law will go as far as finding an heir where there's no male heirs or even no heirs available. It will go to, in fact, I just paid out an estate yesterday where there were no children, but only siblings and a surviving spouse. So the siblings and the surviving spouse got, and there were 2 adopted children. And then what the siblings and the surviving spouse, they gave a portion, each one gave a portion of their inheritance to the adopted children, because adopted children doesn't inherit in Islam either, but you can leave them from the 1/3 portion of where you have a discretion, right? The state, if no heirs are found, that's difficult nowadays to find a person with no heirs. Would be very difficult, but that actually does happen. We had a case not last year, the year before, where there were absolutely no heirs, and it went to the local mosque for the benefit of the community. Right. Gavin, I don't know. I'm not sure if you want to add anything onto.
I'm just trying to find my
slide.
unmute. Sorry, Walid. Can you hear me now?
Yeah, can you hear you?
There you go. So I think on this slide for me, I think my understanding of these priorities and these fixed shares are that if we looked at our fixed shareholders there at the top, number 1 listed there, we are distributing in terms of Sharia law. If any of those individuals are living, they have a preference with inheritance. So they will always receive a portion of the estate if any of those stakeholders are still living at the time of our deceased passing. And then our residuary heirs would receive whatever is left of the estate after those fixed shareholders have received their portion. Am I correct in that understanding?
No, so the residuary heirs would receive if some of the fixed shareholders are not there.
Okay.
Because if fixed shareholders are there, then the entire estate, other than the 1/3 portion, if that option was taken by the testator, would then go to the fixed shareholders.
So our 1/3 portion will only apply if our deceased entered into a will. If we're dealing with
Yeah, correct. Yeah.
unlikely that 1/3 won't go to our fixed shareholders.
Correct.
Perfect. Okay, so I think that clarifies it for me. And then I see that we've got number 4 there as well, that there is provision made for it to devolve on the state as well. Is this similar as our Intestate Succession Act, where it will go into the Guardian's Fund, or is it a different type of treasury that it goes into?
So what we've done in the past is that when we don't, I've never had to deal with a situation where it actually goes to the Guardian's Fund, right?
Most people will sign a redistribution agreement to have
people sign a redistribution agreement or something to that effect. And then also, I suppose, depending on the value and whether the person was connected to one of his local mosques or something, it can be left to them, because what happens is the mosque, as you've got it there at the bottom, has what is called a Baitul Mal, and that is the department within the mosque that sees to the needs of the underprivileged within the specific area. So if the deceased was from that area, to go to that mosque, and they will see to the underprivileged there that is needy in respect of food and things like that.
Perfect. Thanks, Walid. I think that clarifies it for me. I'm sure we'll have some more questions when we get to our Q&A section. I do have just a practical example for us to work through. I'm not sure how accurate my shares are here, but you can maybe, sorry, before we get to that, I just wanted to have a look at how we deal with disputes arising from our distribution in terms of Sharia law as well. Of course, we know then that if we are dealing with our secular wills, we do approach the courts if there are any disputes between family members. And under Sharia law, as I'm sure we get with any deceased estates, there will be some disputes between the family members when we are dealing with administration of the estates. How are those disputes resolved when we look at our Islamic wills as well as our distribution in terms of Sharia law?
Okay, so as we've got it on the screen, right? It's a principle within the Quran that when there's a dispute, never mind whether it's inheritance-based or any other form of dispute, one has to first deal with the dispute between yourselves, and then we look at family to assist with mediation, or you look at an Islamic scholar or an Islamic body to provide that mediation and facilitation in terms of resolving that dispute. It's very difficult to actually take a Sharia dispute to a civil court in South Africa, because you'll find that majority of those instances, the courts are reluctant to make a finding on Sharia principles, right? If it's a simple issue in terms of interpretation, for example, on the will, they might make a finding on it, but they'll never make a finding on whether the Sharia portion is correct or not, right? Because it's a line that they won't cross, right? They would rather refer the matter to the legislature to say, well, you need to enact legislation to recognize this, which is what has happened in the past, right? So therefore, you'll find that most of these issues actually just end up getting resolved within the Islamic bodies and not necessarily at court, unless it's a factual dispute with regards to possibly ownership of property or something like that, or the validity of a will.
So the right approach then would be, if it's something substantive, so something that deals with the Islamic principles and how they will be applied, it's better to approach one of our Islamic bodies like the MJC, or even family members to assist with mediation. But if we are looking at a dispute that is more based on requirements, then we can approach our courts to enforce the requirements under law. If that's
correct, yeah.
So that would be our best approach when we are dealing with disputes when it comes to administration over here. So that makes sense. It's I think a very important part of Sharia as law as well, to involve the family when these kind of disputes arise. Even though the disputes might be between family members, we can always find other family members to include in that mediation discussion.
Yeah, sure.
So I think that's important to understand as well when we are dealing with disputes. And then, of course, if those disputes can't be settled within the family, we can approach the MJC and even the mosques for assistance on that. And then, of course, we do have the last leg as well, which would be to approach our courts. But as you've mentioned, Walid, they're very reluctant to settle disputes that deal with substantive parts of Sharia law. So follow through those processes first before you get to approaching the court. Okay, so then just a quick take on our dispute resolution when we are dealing with administration of estates under Sharia law. Now I've got an example up here where we're going to kind of illustrate how those required shares, those fixed shares, will be distributed when we are dealing with an estate. So we can see at the top there, we've got Ahmed, who passed away with an estate value of 1.5 million, and he's leaving behind a wife, 2 sons, 1 daughter, a father, and a mother. So as we can see, these are all preferent in now I forgot the word, but they'll be our first instance. So we'll identify them and then we'll give them their shares first, their fixed shares. So let's look at step 1 in this instance. Then when we're allocating our fixed shares, the deceased wife will receive 1/8 of the estate. Okay, so this, like Walid mentioned, is not always set in stone. It's best to approach the MJC for a certificate declaring this, but this is just an example of how we would devolve that. So if we take that 1/8 share of the estate, the 1.5 million, the wife will get 187,500. The father and the mother will then each receive 1/6 of the estate. So 1/6 of the 1,500 will be 250,000 Rand each. We are then left with the remaining portion, which will be those portions added together, deducted from our 1.5 million, leaves us 812,500. Our remaining estate is then distributed amongst our children. Okay, so we see we've got 2 sons and 1 daughter. Like we've mentioned, there's a ratio, so the sons will always inherit a 2-to-1 ratio against the daughters. So that means we need to split the balance, our remaining estate, into 5 parts. Okay, if we divide that into 5, then we get 162,500. The sons will each get 2 parts, which means they'll each get 325,000, and the daughter will get 1 part, which is 162,500. And then we have allocated our entire estate, the value of our estate. Is that an accurate representation of how we will divide that estate, Walid, based on the certification that we get from the MJC?
Yeah, that is correct. I want to obviously just state the obvious and point out that we're talking about the net value here. So your executors' fees and all your liabilities, if there's transfer costs involved, anything like that, that's all been taken into account. And this is the amount available for distribution is 1.5 million. Then those are obviously all correct as it is there.
Yes, that's correct, Walid. And I think that gives everyone a better understanding. We do have a product at Lexis as well called Lexis Deceased Estates. Although it doesn't explicitly cater for estates under Sharia law, it does have the capability of you inputting these shares in a way that it will distribute the way you want it to distribute. So I can have a look at that just quickly with you guys. Let me just open that up for you. I don't have that exact scenario prepped for us, but I have a scenario here that I can showcase how easy it is to capture those shares. So on our general details section, on our deceased details section, you will see when we capture our deceased and our spouse, it does give you the option to indicate the marriage as a religious marriage, which will be our marriages under Sharia law. And then we can indicate our spouse as also being married under a religious marriage, which will be our Sharia law. It will include our marriages in terms of Islamic law, in terms of Muslim law. And then when we get to our beneficiaries portion of that, it will list our beneficiaries, and we will be able to allocate that share to each beneficiary. And each asset the system then deals with will automatically allocate that share to the beneficiaries after deducting, of course, our admin expenses and all of our claims against the estate. So then it's quite simple. As you capture your beneficiaries, you will be prompted to give them a percentage allocation, which will be reflected on the certificate you get from the MJC. You simply capture that, And once you've captured each of their allocations in terms of that certificate, the system will automatically apply that to all of your assets in your liquidation and distribution account. So I'll give you a quick view of that once it's done loading over here. So this just simplifies the process for you. So there's no need to work out for each asset which amount each beneficiary is going to get. The system will do that for you automatically. I don't want to take up too much of our time in case we need to deal with some questions, but if we then get to our liquidation and distribution account section of it, you'll see I have quite a few assets listed here once it's done loading. And as we get into our assets, you'll see it will automatically distribute that inheritance to each of our beneficiaries as we've already indicated. So that's just a quick overview of how LexisNexis Estates can simplify those allocations for you. I think we have a poll that they will pop up now for you if you want some more information or a demo of the LexisNexis Estates product. One of our consultants will reach out to you if you indicate that you'd like to be contacted, and they can provide you some more information on that product as well. So that is the end of our presentation. I think we can have a look towards Jamie Lee and George now to see if there are any questions for Walid from the chat. I won't be able to assist, but Walid will be happy to answer them for you.
Yeah, thanks, Gavin, and thank you, Walid. That was really, really engaging. Yes, there are a number of questions here that have come up. Some of them are questions about individual sort of case studies, and I think I can't address all of those. They're just individual matters. But I think the questions that are kind of applicable to everybody, I'm going to try and get to. Probably won't have enough time to get to all of them. The first one, Walid, is kind of aimed at you as the presenter. Where did you get your certificate in Sharia law? Because others also would like to do this course.
Sure. So the one I obtained was from UWC. That was a while back. I'm sure they still have it. I haven't checked recently, but over and above UWC, there's many other institutions where you can do either a one-year intensive course or short courses. So you get institutions like IPSA, for example, Islamic Peace College of South Africa. They accredited institution in terms of as a university. They based in Cape Town. And then there's obviously various organizations. The easiest would be to maybe check with your local authority, either the MJC or the Jamiat in the different provinces, to determine which organizations or colleges there are that does provide these types of courses. I know UWC has always had one. In fact, they've got Professor Munir Abdul Rauf. He's also one of the top Sharia specialists when it comes to deceased estates. He's one of the lecturers there. So yeah, they're welcome to.
Okay.
I think ISA also has, but I think that's a more of a 3-year degree that they have now, and not a short course. Yeah.
Okay, cool. Thanks, Walid. Another question, both you and Gavin referred to the Muslim Judicial Council down in Cape Town and the similar body here in Johannesburg. For other parts of the country, so there was a question, for instance, in Geberga or PE, how do they get hold of the local authority there? Is the internet your answer?
Yes, the internet's your answer. So each province has an authority, right? And each authority falls under an umbrella body called the United Ulama Council of South Africa, right? So in the absence of an authority, let's say it's not easy for you to get access to it, you can just verify with the master's office, but in most instances, they also accept, for example, an affidavit from a recognized scholar. So you can go to your local mosque down the road, get the imam there or the priest there to do an affidavit to explain the different shares. It's obviously easier when you're dealing with the bodies because they are more recognized by the master than any other individual person.
Yeah. Okay, well, interesting. So another thing, I'm making my own, and forgive my lack of understanding and maybe my pronunciation as well. But so am I right in understanding that the Muslim Judicial Council or the body in the respective province will determine the distribution? So they will dictate the distribution. The executor doesn't really have any authority regarding that. And where my question is coming from is there was a question here that said, how do you calculate the deceased's Islamic obligations? For instance, missed fasts, salah, and the outstanding zakat. So I don't understand that, Walid, but my assumption would be that the MJC would make that determination.
Okay, so in that respect, so now we're talking about debts, right? So
Yes.
similar to a secular will, one of the first things that you do is, well, one of the first jobs of an executor is to settle the outstanding debt of the deceased.
Yes.
Right? Now we're talking about before even getting to the distribution of the estate, you have to pay the debts of the deceased. Now, that is something that the executor has to determine. The MJC wouldn't know what liabilities the deceased had, right?
Yes.
So your surviving spouse will, for example, say, you know what? The last time he paid zakah was in Ramadan last year, and he was about to pay this year. Ramadan is starting on the 2nd of March or 1st of the 2nd. He was about to pay, but he hasn't paid yet. So now you know you've got to pay a year's worth of zakah if zakah is payable, right? If the executor is uncertain, they can always pose the question to the body to say, listen, he hasn't paid zakah. Now, zakah, there's obviously a calculation for zakah to determine whether it's payable or not. Other debts like unperformed Hajj must also be paid. There's no issues with salah. So if the person possibly was
We're losing some connectivity. I don't know if it's on my side, Walid.
No financial penalty for winding up the estate. But the Islamic debts is fairly easy to determine. It's either the 2% zakah or it's the unpaid, sorry, not unpaid, unfulfilled Hajj if he hasn't. There's not many other Islamic debts that needs to be paid.
Okay. Interesting. Thanks, Walid. There are a number of questions that relate, which I could probably summarize in one question. Is what happens if there is a will? So there's a will drafted in the secular way, so not following Sharia law in the distribution, but the family wants it to be distributed in terms of the Sharia law.
Okay, that's fairly simple, and it's a common problem because people drafted wills 20 years ago, and they might not have been that pious or anything like that. Anyway, long story short, same answer as previously when it comes to intestate succession. The family can simply enter into a redistribution agreement and do it in terms of Sharia.
Okay.
There is one other question that's very interesting, Walid. Some of the clients indicates that they're not permitted to earn interest. So they'd like to know what happens to the interest that's earned on the deceased estate's bank account.
Okay, so there's two answers there, right? Interest must be given away in a manner that the person that is receiving it doesn't know it's interest, for example, right? Now, you're going to get the clients that says, no, I want the interest, and then you've got to give it to them, but that's an issue on them, right? That they have to answer for that. But the interest, typically, if they don't want the interest, you have to dispose of it, give it as a charity to some community organization for community benefit, right? The easier way of solving that, of course, is to place the funds in a Sharia compliant account, right? So for example, my bankings with FNB, I've got a third-party investment manager. So I open my deceased estates in a Sharia compliant account, so it doesn't earn interest, it earns a profit share, and they can actually, that becomes part of the distribution, and there's no issue with it.
Right.
Yeah, and I know for a fact also ABSA also has Islamic accounts as well as Standard Bank, so that shouldn't be a problem for most of the people, depending on where you bank. I'm not sure about Nedbank though.
Yeah. I think we're out of time. There's still a number of questions. I'm just trying to collate them into, a lot of them are just like sort of individual ones regarding sort of specific. I don't know what wasia is, Walid, but the question is is wasiya an allowable deduction in terms of estate duty?
I would say no, because it's part of the inheritance. It's not an expense or a liability or something like that. That is what you would normally deduct in terms of estate duty. Wasiya is part of your distribution. Wasiya, in simple terms, is a charity. That is the 1/3 portion where you have a discretion in terms of where you're going to give it.
Yeah. Is an illegitimate child legitimized by a later marriage? If the child was born at the time when the parents were not married, but then they get married in terms of the Sharia law, is that child legitimized?
No. Legitimacy is determined by conception.
I see.
So if the child was conceived prior to marriage, then that determines whether the child is legitimate or not.
Okay. Ladies and gentlemen, that's our time done. I see there's still people are slowly
An hour went
trickling.
very quick.
And it's the quickest hour that I've had in a long time. Another pun intended, Waleed. So just on that note, I mean, there are a number of people I need to thank. And the first group of people I need to thank are the attendees. You were a big audience today. Thank you so much. Thank you for the questions. The other question that came up a lot was, do we get copies of the slides? So pardon me. The answer is yes, we have a recording of that. And if you've captured your details, Gavin, correct me if I'm wrong, but that you will be getting a recording of this webinar. So yes, you will get that. So that was a common thread question. So thank you to all the attendees, and a very special thank you to you, Waleed. I mean, we really appreciate your presence and your insights and your valuable knowledge today.
I must thank you guys for having me as a guest, first of all. So I really appreciate it. Thanks.
No, not at all. And I mean, I was super intrigued, and I really think this is probably a topic or portions of this topic that we need to revisit again. And I'm sure that our polls will tell us that as well. Gavin, Jamie Lee, my regular compatriots here on the webinar, thank you very much for your attendance today. And on that note, thank you, everybody. Have a good afternoon further, and look out for the details for webinars in the future. Thank you very much, and have a good afternoon. Bye-bye.
Thanks. Bye-bye.
Bye.
Bye.